Good afternoon, everyone, and thank you for joining us today. My name's Zoe. I'm the Marketing Manager at Aon. This is Isabella, the Partner and Growth Manager for Real Estate, and we'll be hosting today's session. I just wanted to start by saying, here at Aon, we're a proud partner of REIQ, REIWA, REISA, REIV, and REINT, and I'm really looking forward to today's session, where we'll be looking at common claims for real estate agents, taking a deep dive into real-life insurance claim case studies, and sharing best practice for what to do in the event of a claim. A bit of housekeeping to start off with. If you have any issues with sound, please check your settings and internet connection. We'll be recording the session and I'll be sending in a follow-up email over the next couple of days. If you have any questions during the session, please put them in the chat box. You can find the chat box in the bottom right-hand side of your screen. Only myself and Bella will be able to see your questions, and we'll go through as many as we can in the Q&A taking place after the presentation.
I'd now like to introduce our speakers for today's session. We have Peter Lynch, who is the National Client Relationship Manager here at Aon, and Michael Gapes, who is a partner at Carter Newell Lawyers Financial Lines Group. Peter is a leader in professional indemnity insurance in the real estate, valuation, management rights industry sector. He boasts over 34 years' experience with Aon and has a strong interest in promoting safe and quality business practices in real estate. Peter has been a regular contributor to course material, presentations, editorial submissions, as well as guest speaking at training forums for the REIQ, REIA, REINT, REWA, and various franchise and training groups. So welcome, Peter. Also, a warm welcome to Michael Gapes. Michael is a partner at Carter Newell's Financial Lines Group, where he specialises in defending professional indemnity claims across a broad range of industries, including the property sector. Michael regularly provides training and risk management advice to his insurer clients and various industry organisations, as well as actively contributing to the profession as a member of the Queensland Law Society's Professional Conduct Committee, the Australian Professional Indemnity Group, and the Australian Insurance Law Association. Thank you for joining us today, Michael.
So just going over the agenda for today, Michael and Peter are going to be discussing common claims against real estate agents, case studies of sales claims and best practice tips for sales agents, case studies of property management claims and best practice tips for property managers, risk mitigation strategies and effective risk controls, and what to do in the event of a claim. I'll now hand over to Peter and Michael to get started.
Thank you, Zoe.
Thank you very much. I thought just to set the scene, I'd share this pie chart with you all, which shows the types of claims that we've seen across Australia against real estate agents in the past 12 months. So you'll see that the most frequently occurring claim against real estate agents are personal injury claims at 29% of the overall claim numbers. So these are trips and falls on residential rental properties, accidents at open home inspections, injuries at commercial buildings, and at shopping centres and shopping centre car parks. Plaintiff law firms generally adopt a scattergun approach to these types of claims, so you'll end up with multiple respondents or defendants. So as well as the owner, the property manager or sales agent will be joined. You may get the former property manager involved, the previous owner if the property is sold in the past couple of years, tradespeople who've worked at the property, and even building inspectors who may have done a report on the property years ago. The second most common claim we're seeing are sales claims. So these are claims against sales agents by sellers and also buyers and potential buyers. Generally speaking, the higher the sales price, the larger the quantum of the sales claims. Third most common claim we're seeing at the moment are mismanagement claims that account for 20% of the overall claim numbers. These are claims against property managers by landlords and tenants claiming that the rental property has been mismanaged in some way, resulting in a financial loss to them. So these three types of claims, personal injury, sales and mismanagement claims, make up over 3/4 or 77% of all claims against real estate agents. The other types of claims that we're seeing are cyber claims.
I might just jump in there if you don't mind, Mike. It could be a little bit misleading, that percentage there, because that is only related to cyber claims that arise from the extension on the professional indemnity policy. So
that's correct, Pete. That's correct.
There is a lot larger pool of cyber claims out there happening on standalone insurances, and we particularly aren't delving into cyber today. That's on another session. But I do want to point out that, obviously cyber claims are very much in a growth cycle.
Oh, extraordinary. The growth year on year of the cyber claims has just been exponential, Pete, and the cyber criminals are becoming more and more cunning and much more sophisticated.
Yeah.
It's a real problem for the industry, particularly with, agencies, larger agencies, smaller agencies with rental monies and sales deposit monies going through their trust account. They're a very, very easy target. The other types of claims we're seeing are employment practices liability claims, which are claims brought by sales agents and property managers against their employers, misrepresentation claims and discrimination claims. So we'll start off with a few sales examples. The first example involves an agent selling a luxury property on the central coast of New South Wales in late 2021. So the buyer was based in the UK. She saw an advertisement on realestate.com and sent the sales agent an email about the property. Sales agent sent her an electronic brochure for the property, which said that it was a beautiful family home built with character and charm. It had a sparkling solar heated 30-foot in-ground pool. It had verandas with sea views, and it had hardwood timber flooring downstairs. The buyer entered into an unconditional sales contract in early 2022. She didn't know anyone in the area, and she didn't obtain a building or pest inspection or evaluation of the property. And therein lies the problem. She rented the property out for just over a year and moved in a few months ago in May and discovered some harsh realities. The property doesn't have sea views. It's not close to the beach, and in fact, it's 1.4 kilometres as the crow flies from the beach. And there is absolutely no outlook at all other than over rooftops and a factory to one side of it. The pool certainly isn't sparkling, and it has substantial cracks in the walls and sides, and the solar heating didn't work. And the downstairs flooring was a laminate and not hardwood timber flooring. The buyer made a complaint to the New South Wales Office of Fair Trading in relation to the agent's conduct. The OFT, because they couldn't get a resolution of the claim, closed the matter. So the buyer then issued a civil claim against the agent in the district court seeking damages of $200,000. She says that represents what she paid for the property, the difference between what she paid for the property and its true value given the agent's misrepresentations. We're going to mediation on that one shortly, and we're in the process of getting our own forensic valuation report, which will hopefully reduce that quantum. But certainly, I think we'll be attending with a checkbook on that occasion. The second sales example I want to run you through is from Western Australia, and this is another interesting one. Our insured sales agent was engaged to sell a property on the outskirts of Perth in 2021. The buyer asked the sales agent for a recommendation for a pest inspector, and the sales agent got his associate to send through the details of a local pest inspector he had previously worked with. The buyer, for some reason, then decided to use his own inspector and asked the sales agent to arrange for her preferred contractor to go through and conduct an inspection of the property and prepare a report. The associate mistakenly overlooked that email and arranged for the local pest inspector that they'd put forward to carry out the pest inspection. Copy of the report was obtained and paid for. The agent and even the buyer don't notice that it wasn't from the buyer's preferred pest inspector. And the report came back favourable, saying that there was no termite activity or damage to the property. Buyer then moves into the property late last year and discovers not only live termites, but some really, really extensive termite damage that had been present for potentially decades, particularly in the flooring. The buyer then gets her preferred contractor to go through, obtains a second pest inspection report, who says that the house is largely riddled with termites and uninhabitable. In fact, it appears that the sellers had actively taken steps to conceal the termite damage. they'd installed new laminate flooring over the top of the hardwood damaged floorboards. And the buyer has quotes for the rectification works, which are estimated to be about $90,000. Now, our problem is that the pest inspector that did the original report appears to have gone missing in action. He's no longer licensed, and his mobile telephone number and email address are no longer connected. So we haven't been able to contact him. The buyer makes demand on the sellers, who've also adopted a approach of lying low. So the buyer has now issued district court proceedings against both the agency and the sellers, which we're in the process of defending. A third sales example I want to touch upon is from South Australia. This occurred last year. Sales agent was appointed to sell what he described as a renovator's delight in an inner city suburb in Adelaide. The sellers had basically outgrown the property, and they'd commissioned, before they decided to put the property on the market, they'd commissioned an architect to draw up some concept plans for a double-storey extension at the back. It would have added a pretty large ground floor kitchen and open plan entertainment area downstairs, and a master suite upstairs with a walk-in robe and ensuite. The sellers made the concept plans available to a sales agent who forwarded them on to potential buyers. Potential buyer showed quite a bit of interest, and he was particularly interested in what the build costs would be. Sales agent said he didn't have any firm costings, but just made a guess. He said that he thought it would be about $300,000 based on his building experience. The buyer then enters into a contract on the strength of the sales agent's representations. And then the buyer goes about getting quotes from builders once he settles on the property. Unfortunately, though, the quotes range from between $500,000 to almost $700,000. So a lot more than the initial estimate provided by the sales agent of $300,000. The buyer issues proceedings against the agency and the agent for misleading and deceptive conduct under Section 18 of the Australian Consumer Law. We've defended the claim. We're just at the very early stages of the claim, but we've defended the claim on the basis that the buyer was legally represented throughout the transaction and was certainly in a position to obtain his or her own expert advice and quotes prior to entering into a contract to purchase the property. And we've also highlighted that there was a disclaimer clause in the marketing material. So the learnings from these sales examples, make sure you make full and frank disclosure to potential buyers of all matters within your knowledge that may affect the property and may affect the buyer's decision as to whether to buy the property. You need to discuss with the seller the information that they're aware of, which may affect the property, before passing that information on to potential buyers and tenants. You must disclose all information which may affect the property. So any latent defects in the quality of a property, so if you're aware of any termite damage, even historic termite damage, any subsidence issues, or any boundary issues, which are particularly prevalent in older areas, inner city areas, all around Australia, you must highlight these issues. I know you've got to act in the best interests of your seller clients, but you're doing yourselves and your sellers no favours if you don't disclose these issues, which may well be a deal breaker for some potential buyers. Any material facts, and I've noted on the slide there a decision from the Western Australia Supreme Court by Ms. Thilingaratnam against Mr. Doan. That is a really interesting decision involving a claim by a unit buyer against a seller who said that the seller had failed to disclose the presence of some antisocial neighbours. This particular buyer had bought a ground floor unit, and unbeknown to her, but well known to the sellers, there was a very antisocial neighbour immediately above her unit that she'd bought, who'd been subject to many, many complaints to the police and noise control. The agent wasn't involved because the agent wasn't aware of any of the issues with the antisocial neighbour. But the buyer ended up successfully suing the sellers for failing to disclose the neighbour. Now, interestingly, she only paid $390,000 for the unit, but she was actually awarded damages of $258,000 to recognise the diminution in value occasioned by the troublesome neighbour, the time it had taken to actually get through the court system, payment of her costs and interest. So pretty salutary lesson there for that seller, but also agents. If you're aware of antisocial neighbours, you've really got to speak very carefully to your owners and make sure that you make the appropriate disclosures. Also stigmas. These can be really wide-ranging and include untimely deaths at property. And you've probably heard of the Hinton decision, which is a New South Wales decision involving multiple deaths at a property. It was very well publicised when it occurred, and the poor old agent was found liable there. Undesirable, troublesome neighbours, and I've just spoken about that Doan decision, and paranormal activity. Over the past probably 5 years, I've had at least half a dozen claims where buyers of properties and tenants even have brought claims against agents and either sellers or landlords, claiming that the agent and the landlord or seller has failed to disclose paranormal activity at the property they've either bought or rented. Anyway, so some more learnings from these sales examples. Be honest about the condition of a property. Don't airbrush out the defects. This is particularly important where you're dealing with overseas and interstate buyers buying a property sight unseen. They're relying on you, particularly if they don't have anyone walking through or any independent expert advice, anyone taking photographs on their behalf. It's really important that you don't start photoshopping out any defects or gloss over anything that they really should know about. By the same token, you should encourage all buyers to make their own inquiries and obtain their own expert advice. So, as I said before, building reports, pest reports, legal advice. And if you don't know the answer to the question, don't guess the answer. And that's what got our Adelaide sales agent in trouble. He thought he knew all about building costs, but clearly didn't. And that's why he's being sued now. Know your boundaries. Don't go outside your area of expertise. If someone asks you for an opinion on a building price and you're not a builder, don't guess. And use a disclaimer on all marketing material. It's not a complete defence to a claim, but it absolutely helps. So, some best practice tips. Probably actually restating what I've just run through, but just make sure that all representations and statements that you make as a sales agent or a property manager for that fact are accurate. Act as a mere conduit of information only, so pass on information obtained, but don't put your own spin on it. Don't interpret it yourself. Let your buyers interpret it themselves and make further inquiries if they need to. And obtain information from reliable sources only. Don't believe necessarily, what your sellers are saying about commute times or the number of planes that are on the flight path immediately over the property, or the quality of the neighbours necessarily. By all means, make those inquiries, but just be very discerning on what you put in advertisements. And on the topic of advertisements, obtain the written approval from the seller to disclose all the information that you've been given, and have your sellers verify by signature or by email the accuracy of all information and marketing material before they're published. And by that, I mean print media, online advertisements, flyers, anything at all. Make sure that you send it to them in draft and get their written approval before you distribute it to the wider public. That is very, very critical, because it certainly helps us when we're defending you, and we can say that you were passing that information on in your capacity as a sales agent, and you are the mere conduit of information. And be upfront to your buyers about where you got that information from. If they ask you, say you got it from a seller or say you got it from RP Data or wherever. Don't say that you got it from yourself. Be very upfront about where you got it from. And coming back to disclaimers, just make sure that they're on all information and documentation provided. And when I say that, I say make sure it's on every single page. Don't just put it on the last page in font size 6 because no one will read it. It needs to be a decent font size, legible, understandable in plain English on every single page of every single piece of material that you forward on. And draw the buyer's specific attention to a disclaimer and make sure that your disclaimer says that the information that you're forwarding on hasn't been verified by you and that you haven't checked the accuracy of that information, and encourage the buyers to undertake their own investigations and seek their own professional advice.
You know, I imagine,
really
Michael,
important.
it's crucial to have the emails and file notes to back you up on these things when you do have that problem, because
Absolutely, Pete. Claims can be brought up to 6 years after events. So creating a paper trail in the first instance and saving that paper trail are absolutely critical. And we'll talk about record keeping in a minute, but the other observation I would make in relation to record keeping is sales agents will come and go, just as property managers will come and go, and often their loyalties change. They might have jumped ship to the competition, and a claim might be brought when they're working for, another employer. So their interest level will not be quite so high. So often you're not relying on their recollections because you may have to subpoena them, or you might decide not to even subpoena them. So you're actually relying on written records. So it's really important that, you keep your written records and you save them for, best practice is 7 years before you destroy them.
I think it's a great plan for principals to pre-build as much of this information ready for the agent, the sales agent to use as much as possible, because statements that I've seen over the years, like never to be built out, unlimited views.
Yeah, unless the agent is a clairvoyant, I would avoid anything like that. Yep, absolutely. Right, I want to go through some property management claims examples now. The first one is one from Melbourne. In 2020, a long-term tenant of an apartment in St Kilda advised the property manager that she'd overpaid her rent and she wanted a refund of the rent. Property manager said that was fine, and she said she would disperse the money back into the tenant's bank account. Tenant then said, "Oh, look, I've actually changed bank accounts, so I'll email you the new bank account details." Tenant did that, and the property manager, unfortunately, wasn't concentrating, and she mistakenly inserted the tenant's new bank account details into the landlord section of their property management software. The tenant kept paying rent, and this is from early 2020, for the next 2 years, and the rent was about $600 a week from memory. And the agency was refunding it straight back to her a couple of days later after deducting its property management fee. The landlord was a very valued client of the agency. She had multiple properties with them, and she discovered in late 2022, when she was doing her tax return, that she hadn't received any rent from this particular property for over 2 years. Property manager says she'll investigate, goes into her software and realises that money has been paid straight back to a tenant. By the stage, the tenant had moved, and she'd moved interstate. She's moved to Tasmania. And we get involved. We start sending emails and letters of demand to the tenant. She's not responding. And in the meantime, the landlord has lost patience, and she's issued a claim in VCAT against the agency. And we have in turn joined the tenant to the proceeding. So that's one that's still going on. We haven't been able to ascertain whether the tenant still has the money. I suspect she probably doesn't. But that is just an example of a very simple administrative error that is going to prove very, very costly for that agency. Another example that I've got here, which again is just a really simple error, and I'm sorry to harp on about this, but it just demonstrates that attention to detail is really important. because that's how a lot of these property management claims arise. So this is one where a property manager does a routine inspection and discovers a leaking roof. He provides the inspection report to a landlord and seeks instructions to obtain quotes. Landlord comes back and says, yes, you should obtain quotes, but I don't really want to replace the entire roof. I just want a patch job where the roof is leaking. Property manager then engages a contractor, roofing contractor who they'd worked with before with no complaints, who provided a quote to patch the roof at a cost of almost $7,000 and a cost to replace the entire roof at a cost of $38,000. Property manager forwards them on to the landlord. The landlord comes back and says, I'll take the quote for $7,000. Thanks very much. Property manager, in his haste, emails a contractor and rather than distinguish between the higher quote and the lower quote, just says, please proceed as per quote as soon as possible. Contractor, perhaps understandably, replaces the entire roof and sends an invoice to the property manager for $38,000. Property manager's heart sinks when he opens the email and realises that he wasn't specific enough when he instructed the contractor. So the situation we have at the moment is the landlord's refusing to pay for the entire cost of the roof. He acknowledges that it probably was on its way out and he would have had to have done it in the next 5 years anyway. But he's saying, well, I can only afford to pay $7,000, so I'll pay the contractor. And you, property manager and agency, need to pay the difference of $31,000. So again, very expensive lesson for that agency. And it's one that could have very, very easily been avoided just by being very pedantic in the language that's being used. The last property management example we're going to run through is one from Queensland. It involves a property in far north Queensland. A tenant of a property, he's a shop manager, said that he suffered an electric shock when he turned on a light switch in the bathroom of his rental property. He says he was thrown backwards onto the ground. There were no witnesses. He lives on his own. He says that he has suffered nerve and muscle damage to his arm, burns to his feet, which appear to be true, a head injury, and also a condition known as complex regional pain syndrome. It's a relatively recent medical phenomenon, and the experts are very divided on that condition. It's very, very contentious. But anyway, the tenant had said that he had advised the property manager that the electricity shorted after the rain on many occasions. The property manager denies that's the case. The property manager, though, says that she was well aware that the roof was suffering from multiple leaks. It was an older house, a Queensland-style house. It had suffered very, very badly in various cyclones, and particularly since Cyclone Debbie in 2017, there had been a long barrage of complaints from this particular tenant about the roof, which the property manager just hadn't forwarded on. She appeared to accept that that was just life living in Queensland in Cairns. And the tenant battled through, but continued to make complaints which were largely ignored. So after the incident, the property manager got an electrician out. The electrician replaced the safety switch, but said that he couldn't actually see any defects with the switch or the safety switch. But just to reassure the tenant, made those repairs. So the tenant then issued a claim against the agency and the owner of the property. The owner lives in Brisbane, hadn't been to the property for years, hadn't been given copies of any of the inspection reports. And as far as the owner was concerned, there were no outstanding maintenance issues or any repair issues with the property. We went through the pre-court process we have here in Queensland called the PIPA phase. It didn't resolve at a mediation in early 2022. So the tenant has issued proceedings in the Supreme Court of Queensland out of the Cairns Registry. Now, being a lawyer or defendant insurance lawyer, that concerns me because it is very, very difficult to win cases involving personal injury claims up in far north Queensland. The tenant hasn't worked since the incident. He is 49, so he's got about 18 years before his normal retirement age. He's a store manager on, I think, about $70,000 or $80,000 a year. There are 8 medical reports. Various experts appear to confirm the burns to his feet and the head injury. And the opinion is divided on the complex regional pain syndrome diagnosis. And that really is a big ticket item in his claim for damages, which is $2.2 million. So that is a claim that we're going to mediate next month. And we're very much hoping that we will be able to resolve that claim because, as I said, I really do not want to take the risk of defending the claim in a Supreme Court in far north Queensland.
Yeah, careful how I hop into this one, but yeah, look, I think we all know that you're really at the mercy of the judge you get on the day,
Absolutely.
and they do tend to take a view of being concerned about the litigant or the claimant. But I think a broader picture, Michael, I might ask you to comment on is something we've noticed, particularly in North Queensland, but not just limited to North Queensland, is for property managers and business owners to really look at the quality of the properties within their rent roll and
Absolutely.
Whether you've got to make a hard decision in some cases of whether you really want that property on your rent roll because, putting aside the fact you've got insurance to cover you for this, it's the time and the work involved and back looking for files and back and forth between, property managers. And as you said, the turnover in staff issues, it's a massive headache, and being insured obviously is the best thing, of course, but it doesn't mean it takes away all the pain and the work you've got to put in with the claim.
As you've seen for the pie chart I put up, the mismanagement claims and the property management claims are so prevalent. We get hundreds of them every year. And I would say, no exaggeration, at least a third of the principals that phone up or property managers that phone up to notify a claim who I speak to say, I knew I should have got rid of this property, either because it was a troublesome tenant who'd been threatening to make trouble, or it was a landlord who didn't want to spend money on the property or refused to get landlord's insurance. I'm never going to say to a principal or a property manager, there's some business you don't want and this is it, get rid of it. I'm not there to destroy people's businesses or tell them, what to take on or what not to, but go with your instinct. If a property is in poor condition, it's poorly maintained, and your landlord doesn't want to spend money on it, nothing good is going to come out of it.
Yeah, and I think the other thing, Michael, to bear in mind too is that government legislations nationally are changing regards minimum standard of housing. So
totally, and it's coming to Queensland on Friday. So
if you're living in Queensland, think about that one. But certainly you've also got the government, and obviously that's been brought on by a number of major. Not only deaths, and we've had some tragic ones and injury claims that have brought the government back. So you've also got that against you as well.
Yeah, but the job of a property manager is getting increasingly harder because the bar is getting set higher and higher. And as you say, minimum housing standards coming in, just makes the job that much more difficult. So look, I've probably actually, spoken to most of these points in the examples, but I just wanted to distill down where I see most of the claims arising in property management. The big ticket item is inadequate inspections. Ticking the box, just walking through the property without doing it adequate justice. And Pete, you've got an example there, I think, of a well, I was just going to routine inspection that you brought in.
Yeah, it's this. You get from one extreme to the other. Those that don't do the inspections, and I might comment, Michael, on whether the statistic is still true, but it used to be a statistic that 60% of our property management claims arose out of failure to do proper inspections.
I think that's a fair assessment.
Yeah.
Yes.
But then you get the extreme example, and this is one probably hard to see, but a client provided for a claim that we've had, a property manager, And-
60 pages of photographs.
60 page of photographs of a particular property. I mean, if it burnt down, you could rebuild it off their photos.
Yeah, yeah.
That's an extreme example.
Well, it is, but therein lies our defence to the claim.
Yeah.
You know, we had doubts about the, you know, the authenticity of the claim, and certainly the property manager thought that it was vexatious. And I thought, okay, that's great. But when we got that, we thought, well, okay, this is defensible, which is absolutely terrific, you know. But I've got to say that the standard of the property management record keeping has dramatically improved over the past 5 years.
Oh, look, and the insurers a few years back give us the ability to waive the property management excess as long as you filled in the risk management request, which was, I think from memory is basically that you've got a property management agreement in place, that you use a qualified tradesperson that's got public liability insurance, and that you've got proof of doing regular inspections.
Yes.
Now that's all conditions are within the Act.
Yep.
Now, if at the time Carter Newell get a claim and they could tick the boxes and all those, your insurer will waive your excess, and that's
right.
the big thing. And
That's right.
I think our latest statistic now, which I'm exceptionally proud of, is that, and correct me if I'm wrong here, but 85% of our property management claims obtain a nil excess or a waived excess. So I think there's been a massive increase, I suppose, increase in the ability now to track these better with software, and that has made this so much better.
That's right. Absolutely, Pete. Absolutely. Absolutely. So look, just coming back to these points, inspections not occurring regularly, or entering condition inspections not being completed at all. I see that a little bit. Failure to adequately complete inspection reports goes back to a point about inadequate inspections. Failure to send the inspection reports to lessor clients. You know, I would probably be able to get a really good contribution to my personal injury claim in far North Queensland if my property manager had actually bothered to forward on the inspection reports to the landlord. Because once the landlord's knowledge equates to yours, and you've sought instructions to carry out repairs, you've discharged your duty. It's the landlord's problem if he or she decide not to undertake repairs, and you can then do something about that. So that's a very, very simple fundamental point, but often gets overlooked. And failing to seek instructions to remedy repair or maintenance issues, and failing to follow up as well. It's one thing to send the reports on, but do a covering email or do a covering letter, whatever your property management software or your old school system permits. Just summarising, you know, the instructions that you need, and diarise it. You know, if it's an emergency repair, consider under your state or territory legislation whether you're able just to go ahead and do it. If not, follow up every couple of days until you've got a yes or a no, and then you at least know where you stand, and you can keep the tenant in the loop. So look, I'm just going to run through some best practice tips for property managers. Like with sales agents, remember the eyes and ears of your landlord clients, particularly your interstate landlords. They're relying on you to accurately convey the condition of the property and information about the property. And it may be information about a troublesome tenant. I mean, certainly if tenants in arrears, your landlord would want to know. But if they're being difficult, if you're getting complaints from neighbours about them being troublesome, if they're issuing vexatious breach notices, that's the sort of information that your landlord clients need to know. If they're local, even if they're not local, encourage them to attend inspections so they can see the condition of the property themselves. As I said before, make sure the landlord's knowledge equates to your own, because they should be the ones carrying the risk. They're the ones with the investment in the property. You guys are the ones just doing your job and paying a fee for it. Take lots of photos. Not suggesting that you necessarily need to take 60 pages of photos, but that would be great. But attach these to the inspection reports so that there's documentary evidence there of the condition of the property.
I think, Dylan, could I just add one? I think it's a very important one, Michael, is that in all my years of being involved in slip and fall claims on rental properties, and whether that be the tenant or the guest of the tenant or somebody visiting for other reasons, I see property managers exceptionally diligent in letting the landlord's insurer know that there's been a slip and fall and report, and not realising that they also should be talking to their principal about notifying their own professional indemnity insurer. because you can be as sure as anything that if there has been a slip and fall on a rental property, the KPIs that are given by the insurers to their loss adjusters are bring the real estate agent in on the claim straight away. So if you've got a matter that's serious enough that somebody's been injured on your landlord's rental property and you've notified their insurer,
Yes.
you need to.
Yeah, and look, Pete, that's a very good point. And I come back to that pie chart at the start of the presentation, where we were talking about, personal injury claims. Plaintiff law firms adopt a scattergun approach. They often don't even look at the merits of the claim. They just bring in as many people as they can. And I go to all sorts of informal settlement conferences, mediations, where the plaintiff barrister gets as many people in the room that have any tenuous connection to a property. And even if the claim is completely unmeritorious, they all say, well, what's the insurer going to put in? Let's all club together some money. And it doesn't really work that way. We will defend the claim on its merits. It's not a numbers game as far as we're concerned, or the insurers are concerned. But the other side see it that way. And I have an example before Christmas last year involving a trip and fall on a rental property, short-term holiday property up in Newell, Pete, where there were 8 respondents to the personal injury claim. We were one of them. We were the former property manager who'd handed over management to the new owners who bought the property, I think, middle of last year. There was the on-site manager, had nothing to do with the unit. There was the building supervisor. There was a body corporate manager. It was a cast of thousands. Yeah. And we all went around the room and said why our respective clients, had no legal liability. I suppose the message I'm trying to convey is just to, endorse what you said, Pete. Don't think that you won't be joined, because you will. You might be the most perfect property manager. You might have done everything right. And you might not have a legal liability to an injured claimant or plaintiff, but it doesn't mean you won't be joined. And as you say, Pete, notifying the landlord's insurer means that you should be notifying your own insurer, and it costs you nothing to do that. Your insurers would far rather that you be prudent and you put a marker down just on a precautionary basis, and they'll be as happy as you are. It doesn't go anywhere, but at least you put that marker down. So if the claim does escalate, or the matter does escalate into a formal claim down the track, they're then able to reopen their file and take steps to defend you.
There is nothing worse if you're going to have a discussion with your insurer, particularly after your insurance has expired, or you've moved on to another insurer, and you get a claim notified, and then they say, well, why didn't you notify this earlier?
Yeah.
Then you've got all sorts of situations about late notification and whether they're going to grant you indemnity. You don't ever want to be in that position. So thinking that by not notifying it's going to save your premium, it's not, because they're not going to actually load your premium up simply on a notification. Potentially, maybe if there's some cost and all that, but it's far better to be prudent than not.
Absolutely. Now, I just want to run through some extra property management tips here. Don't be shy about using your spend authority. We see a lot of personal injury claims involving trips and falls down the stairs where there's a dodgy stair tread, and the property manager's got up to 2 weeks rent to spend, and they get the stair tread replaced at a cost of $100 or something, well below the spend authority after the incident. So I suppose my advice to you is go through your appointment documents, find out what your spend authority is, and be prepared to use it. And if it's not appropriate, if your authority document is out of date, update it. Get a spend authority that properly represents the cost of doing repairs to rental properties, so you don't have to keep going back to your landlord for instructions to conduct routine repairs. As I said before, if you get a repair request in, assess whether it's urgent, because it might be an emergency repair under your state or territory legislation. Just a best practice tip: seek instructions from landlords in writing or email. Create a paper trail. If you do have to do it on the fly on your phone, do it by text. Save a text. Save it to your system, so you've got a record of having sent it. And if verbal instructions are given, send an email back to a landlord, just close the loop and just confirm back to them in writing what their instructions are. And as I said before, have a bring up system to ensure that any repair requests are followed up and you get instructions in a timely manner. And as we said before, if you don't get instructions and you think it's a legitimate request, well, maybe it's a property that you don't necessarily want to manage. So have a word to your principal. Take repair and maintenance requests seriously, deal with them quickly and proactively. I mean, it's stating the obvious. Have proper systems in place to deal with repair and maintenance requests. As Pete said, in the Aon real estate policy, there is an ability to have your deductible waived if you're able to demonstrate that you've got a system in place to deal with repair and maintenance requests, and you tick some other very, very obvious boxes. Ask tenants to complete written requests. We get so many claims where tenants who've been injured at rental properties say that they were repeatedly making verbal complaints. And the property managers are denying that black and blue. If you have a blanket system whereby you refuse to accept verbal complaints, you're at a very good position to defend any suggestion that you've ignored any verbal complaints. Ask your tenants to supply photos of request as well, so that you can assess whether it's an urgent request, whether it's a safety issue, whether you need to go out there and cordon off the front set of stairs while you're getting them repaired, and you send an email to the tenants saying you to use the back set of stairs. Forward all this on to the landlord as well. It's a bit like my point with the sales agents. Make sure that the knowledge that you forward on to your landlord so that everyone's on the same page. And use appropriately qualified, licensed and insured contractors. Get a contractor appointment form up and running, get their qualifications, and have a bring up system so you've got their licensing and insurance documents on file. If my pest inspector had an insurance in Perth, on the example that I mentioned a few moments ago, we would certainly be going after him. But he's disappeared and he's no longer licensed, and we don't believe he carries any insurance. So, that's one where the agency is going to be effectively wearing his share in that settlement, unfortunately. So that's, I think, a good example of the need to really use licensed and insured contractors. Actively discourage your landlords from doing their own repairs. Nothing good comes from that at all. Or appointing or arranging their own contractors. Most landlords want to save money, particularly in this economic climate. And we've seen multiple claims where they've sent an unqualified handyman or they've tried to do repairs themselves. And those repairs have actually resulted in accidents and injuries to tenants.
I could not argue on that one enough, Michael. I've seen a couple of examples of my own clients where this has happened, and it's messy, and the landlord then saying, no, I definitely thought you were going to do this. If you are going to let them arrange their own repairs, their own contractors, you want to make certain that's really built into the property management agreement very, very clearly.
Yeah. And look, for any repairs at all, and if a landlord is doing his or her own repairs or getting someone to do them on his or her behalf, you should inspect them to satisfy yourself that those repairs are adequate. If you are sending out your own contractor who you trust and who's insured and licensed, think about whether you need to go and inspect it. If not, ask your tenant to send a photo just to confirm that those repairs have been done, and ask the tenant whether he or she's happy with the standard of repairs. And if they're in any doubt, go and take a look.
I think, Mike, you only got to think back to that High Court case many years ago here in Queensland where the unlicensed electrician did some work on a stove in a property outside of Charters Towers, and poor 11-year-old girl went to turn the tap off and become zapped and was brain dead. I mean, It was just terrible.
Yeah. So look, just a couple of comments I want to make, and this really relates to property management more than sales, but just starting off on the right foot. And by that, I mean, get your appointment document right. Make sure that you're not doubling up. We've had numerous instances where people have accepted new managements only to discover down the track that someone else is still managing the property, and a cat fight ensues, or there's confusion for the tenant. And in all of the instances that I've dealt with, the landlord has just forgotten to actually terminate the prior property manager, but just ask a question. Properly identify the correct landlord clients. That's really important. You know, I had an instance up in Far North Queensland a few years ago where a property was on short stay accommodation. It was rented out for thousands of dollars every night. It had about 60% occupancy. The money was being paid into the husband's bank account. It turned out that when the agency took on the property, they didn't do a title search, and the property was actually in the wife's name. The couple divorced, or in the process of divorcing, and suddenly the wife's lawyers turn around and demand about $300,000 from the agency, saying, well, look, our client owns the property, not the husband. We're well aware that the money's been going into that account, but that's his account, not hers. And give us $300,000 within 7 days, please. Otherwise, we're going to sue. So again, pretty simple admin exercise there, which has proven pretty costly. Get them to sign and date the appointment form. I reckon that probably a third to a half of all appointment forms I see aren't properly signed or dated, including any amendments or annexures. Keep the original on file. As I said before, claims can be brought up to 6 years after relevant events. So it's really important that, you know, if you've gone to the effort of getting a signed retainer, that you keep it on file. But set out what you're going to say as well. Take on board Pete's point about, you know, who's doing repairs, who's doing what. Have a clear delineation of what you're going to do so that everyone's on the same page as what their respective obligations are. Set out what your fees, charges and commissions and expenses are. Have an adequate spend authority, going back to my comments earlier on. And if there's anything out of the box or unusual, get a lawyer to draft special conditions. Don't have a go yourself. That's going to be a breach of the Legal Profession Act and could get you into serious trouble. Speak to your local lawyer and draft some special conditions. And just a couple of final comments in relation to record keeping. We've already spoken about this at length in this presentation, but just make sure that your files are comprehensive, file notes of all discussions, anything verbal. Complete the circle, do a file note, send an email back, and it could be conversations with your landlords, tenants, tradespeople, whoever. If you aren't using property management software, that's fine. A handwritten file note is fine, but just make sure you initial and date it. We have had claims where we've had to get handwriting and paper experts in to date file notes, handwritten file notes. So it is really important that you do that. And we've also had to get software experts in to look at electronic file notes and see whether they've been altered after claims have been issued. So, you know, it's very, very critical that you do that. Date stamp or hard copy correspondence coming in. With emails, keep delivery and read receipts and save them to file as well. Back up your systems regularly. Keep all your research. So if you've done any title searches, going back to my example of the short stay accommodation in Far North Queensland, keep that on file. And even if your retainer ends, keep a copy of your property management file, because, you know, a new property manager might be out to slot you, and you might get a property management claim in months down the track. And if you handed over your file, it's pretty hard to defend your position. So, receiving a notification of a claim against you. You know, as we said before, there is every advantage in notifying any potential claims to your insurer or on a precautionary basis at a very, very early juncture, and certainly any claims, formal claims that may trigger your policy as soon as they occur. Once a claim's been made against you, you need to start getting your file together. So start printing off all electronic diary notes and photos, start printing off all emails, file notes, correspondence, draft a chronology of events while the events are fresh in your mind. As I said before, these claims can be brought years after the relevant events, and your staff may well move on. So that's why it's really important to take signed statements from your staff while they're still working for you and while their recollections are still fresh, and keep those on file. And just remember, don't make any admissions of liability at all, because that may well compromise your ability to defend the claim.
I might hop in there, Timo. There's often, I've seen cases where property managers inadvertently have handed over files or made statements to loss adjusters who say to the property manager, look, this has nothing to do with you. I'm just investigating on behalf of the property owner's insurer. Now, as I've said very earlier on, you very well could be in the gun there. So under no circumstances, be giving statements to loss adjusters or lawyers without any reference to the business owner, and of course the business owner speaking to your professional indemnity insurer, because you then put them in the inability to defend you correctly.
Yeah. Any request to hand over documents or statements or anything like that, speak to us if you're insured with the Aon Real Estate Scheme, and we can certainly help you. Often we understand that you want to preserve your relationship with your landlord clients, but at the end of the day, a loss adjuster would have been appointed by the landlord's insurer, and as we've said before, they will be seeking to share that loss with you. So it's very, very important that you preserve your own position and also preserve your insurer's position. So, as we said before, if you're an Aon client and a formal claim is made against you, or you're concerned about the potential for a claim to be made against you, you can call us here at Carter Newell Lawyers. Our telephone number there is on the screen, 1800 624 264. You can also email us on cpm@carternewell.com. And I think we've got time for a couple of quick questions.
Not very long, Michael.
Not very long, but
We've only got a couple of minutes, but we'll jump in quickly. The first question actually came from Daniel, who's asked us, as a licensed stock and station agent, real estate agent and accredited auctioneer conducting on-site auctions, what would you recommend to be the correct cover for both PL and PI at this present time?
Well, I mean, you certainly the minimum is $1 million to start with anyway. Is he talking level of indemnity?
I would suggest.
Yeah. Look, once again, you've got to gauge that on the size. Whatever property you're auctioning, you decide on what you're limiting. What size of your auctioneering. But obviously, the more larger sum insured you can get, the better.
Yeah, I mean, just to add my 2 cents worth, Bella, as I said at the outset when we were looking at the pie chart, the higher value the property, the larger the sales claim. But the other observation I would make as well is that some of the personal injury judgments handed down in favour of plaintiffs run into millions and millions of dollars, particularly involving, infants and people that have been rendered, tetraplegics or paraplegics. So, I don't think that you can underestimate the importance of having appropriate insurance that recognises, the nature of your individual business. Getting the bare minimum cover these days for most agents just isn't going to be adequate in the event of a claim.
Exactly right. But as an auctioneer too, you could also look at the relationship we've got with the working with the principal.
Absolutely.
So there could be some indemnity provided by but that's something you need to talk one-on-one in your own particular circumstance.
Excellent. Another question, this has come from Darren. What do you suggest when the property has recently sold and RP data hasn't updated the property owner's detail to the new owner, and you do a title search and the previous owner's name is on the title, however the new owner has asked our agency to manage the property?
Look, that is a hard one, and I do know there can be a lag of, sometimes up to about 3 months. What I would do then is I would ask for independent evidence that property has conveyed. So I would ask for a copy of the sales contract, and I would probably ask to speak to the parties' conveyances just to make sure that the transaction has settled, and that the landlord is also the registered or the owner of the property. So get documentary evidence, basically.
Perfect. Another question we have here is whether you have any sample claims for brand new house sales.
I do have plenty of examples of brand new house sales. A lot of them have been here in Queensland, I have to say, involving off the plan sales that have been done, during COVID, with disappointed overseas buyers and state buyers who've come up. They've had a look at the concept drawings and had a look at the finished product, and they look nothing like each other. And that's why, I said before, when you're selling anything, regardless of whether it's off the plan or an existing property, you make those potential buyers aware of all features of the property, good and bad, and you strongly encourage them to get their own expert advice. I mean, it may well be that, you should be saying to them, get a building inspector to go around, have a look at the build quality, assess the neighbourhood. If they know anyone in the area and they're not living, in the state, get someone to have a drive around the area and assess the neighbourhood and the neighbours.
Yeah, and it's so crucial at this present economic point in time where we're seeing builders going under and the quality of build is declining as well. I mean, you've really got to encourage any potential purchase to really make as many investigations as they can. I've spoke to a number of agents that have sold up in North Queensland as well and on the Sunshine Coast, where they really encourage prospective purchaser to get somebody totally independent, not recommended by their agency, to come and look at the property.
But also for sales agents as well that are selling off the plan, just satisfy yourselves that those plans and those concept drawings are going to look like the finished product. There's a very interesting decision in Victoria called Rapani, involving Mr. and Mrs. Rapani, who paid, I think, about $6 or $8 million for an off-the-plan property in Melbourne. They were expecting to receive a beautiful open plan area with no pillars between the indoor and outdoor area. And as it became close to settlement, it became very apparent that there were going to be some columns that would basically interrupt the flow between the indoor and outdoor area. And they sued the developer, and the contract got rescinded. And that matter went on appeal relatively recently. So sales agents, just be very cautious about what you say, and get your buyers or potential buyers to make their own inquiries.
Yeah, and obviously the use of disclaimers.
Yes.
Transparency is the key there.
Certainly is.
Just one more question. Unfortunately, we only have time for that. And this one's coming from Rick, and he was wondering if you had any sample disclaimers that you would be able to share or have prepared.
Look, we probably do. I'd probably actually have to speak to the respective institutes about that.
Yeah.
They do have their own preferences, I think, in terms of disclaimers, depending on which state or territory. But that's something that we can certainly make some inquiries about.
Yeah, no question about that.
Okay, everyone. Well, unfortunately, that's all we have time for today. Thank you for attending and participating, and thank you to our wonderful speakers. That was a really informative and engaging session. After this session, I'll be sending out a recorded webinar for everyone and also a survey. So if you had 3 minutes to fill out the survey, just so we can keep giving some valuable content for you. And thanks again for joining, everyone. Have a fantastic afternoon.
And if you had any questions we weren't able to get to today, feel free to email Zoe back when we get the webinar sent out.
Thanks, everyone.
Thank you.
Thank you.
Everyone.
I wonder whether we should get a photo taken by Jack back through to here where we might use it for a LinkedIn post.